Hey everyone, Harry here to talk about Donald Trump's motion before Judge Chutkan for a quote unquote automatic stay of all proceedings. First point, this is like a pristine example of the bizarre situation we find ourselves in. I find myself in where little, procedural junctures in a trial that no one would ever pay any attention to suddenly have, national, if not international, political significance. And let me explain why. So, Donald Trump brings an immunity motion. He says, hey, I was president during this time, and therefore I'm immune, which is to say, I have a right not even to face trial and go through discovery. You've probably seen or you're familiar with similar issues that have cropped up in different Trump litigation, most recently just last week, where the D.C. Circuit, the court above Judge Chutkan, held that they rejected his immunity claim in a civil case. It's come up elsewhere in the very related issue of, was he acting within the outer perimeter of his duties? In which case, that's the test roughly, but the law is very underdeveloped in this kind of immunity question, as you can imagine. It doesn't happen, especially in the criminal context. But does it apply to this case and a criminal case? Okay, so Chutkan denies the immunity motion on the merits. He says, I have a right not to. She has a opinion last week that says, no, it comes out actually the same day as Blasingame. And I think the civil case I was just talking about, where the Court of Appeals above her held no immunity, I think she was clearly holding her pretty long, well-reasoned opinion for that. That very day, she comes out and says, no, Trump, you do not have immunity. This is not a nation of, the president is not king here, was the kind of money quote. All right. Now, though, all these questions are first substance and second procedure, i.e., delay. And from the moment this came out, I identified this as the most likely sort of vehicle for him to impose a substantial delay on the January 6th trial to get him over the November 2024 hump, and all the other ones, Fulton County, Mar-a-Lago, the New York case, which is pretty small potatoes, don't look like they're going to reach there. So the focus has been for a while on January 6th, and now in terms of its happening, the focus is very much on this immunity motion. Okay, having lost the immunity motion, Trump files yesterday what's styled a motion for an automatic stay. And his argument is Judge Chutkan immunity. It's a immunity and double jeopardy. I'll get to that in a moment. Short answer there is it's a total loser. But immunity, a substantial issue. And he says, you now, having decided that you've lost jurisdiction over the case, it's an automatic stay as this thing works its way up to the Court of Appeals. It's a stay of all proceedings which immediately go into a deep freeze until this issue is fully resolved. So that he tells Chutkan, not only you should, but you must enter a stay now. Okay, now, as I've mentioned, this is pretty new, cutting edge, not fully decided claim. Much of his precedent has to do with the civil context. And here, the criminal context, I think, is going to really matter. It's, among other things, a more exigent public interest to vindicate the rights of the United States that are bringing this case. The case, unlike a civil case that anyone can bring, was brought by, a full review out by the Department of Justice and went through a grand jury. So there has already been this extra layer of review as opposed to the easy trigger on a civil case. So that's another distinction, again, on whether they should grant a stay. Most importantly, if you read his cases saying it's an automatic stay, it is not an automatic stay. There's been an area like arbitration where it might be, but really he hasn't made a compelling argument that the stay is automatic and just must happen. I think that one's going to lose. That will leave the question then, should a stay be entered? Because it's a pretty important issue. He's got a colorable claim for a legal position that would not just win the case for him, but give him a legal entitlement not to have to go through litigation at all. And that's why, same thing with double jeopardy, by the way. It just happens to be a lousy argument. But that's why the law generally provides for what's called an interlocutory appeal. Most all of the motions he is losing will be taken up on appeal if he's convicted. That's what, the courts won't just freeze the linebackers like this and take up the issues. Immunity is different, importantly different, because it's a right not to engage in trial and litigation in the first place. All right, but now this sort of real important nuance here is and litigation. So Trump waited a long time to bring an immunity motion. He could have brought it in August. He brings it in November. And during that time and continuing up to the present, discovery is ongoing. He's been getting the benefit of discovery. He's been experiencing the burdens of it. So the idea that immunity is to get you out of the burdens of discovery, in that sense, the barn door is already open, and a court could easily say that the burden's been taken on. There's nothing to be done there, just especially with the important interest of speedy trial and however they want to characterize the important interest of this case and the whole special electoral context, the big election, etc. That's already happening. So a court could well say pretrial litigation can go on. What wouldn't go on in this chain of reasoning? The trial. So let me bring this to ground. I think Chutkan will deny his motion for an automatic stay. I think she'll deny his motion for a discretionary stay. And then what will be really important, and this will happen soon, is that the issue of immunity will go up to the Court of Appeals coupled with a motion for a stay. And then I think that's a pretty strong motion. There's an argument that is sort of circulating out there that he waited too long to make it, and therefore he should be barred from making it under the equitable doctrine of laches. It's technically an available argument, but I find it hard to think the Court of Appeals would resolve this important issue of the stay based on it. So therefore, the question will be, should there be a stay just because it's an important issue to decide? And at that point, it's going to really matter what the panel of the DC Circuit is. So to me, it's going to go up to the DC Circuit on appeal, including the question of a stay. And two members of the panel could grant a stay. So the composition of a panel, you could imagine panels kind of likely to grant a stay. You could imagine panels not so likely to grant a stay. In any event, whether or not they grant a stay, they could grant one, but only as to the trial. And that wouldn't really have much bite unless they keep the issue a long time. But if they either don't grant a stay or they make quick work of it, as the DC Circuit has been doing, Now, would they do it with a very pro-Trump panel? Less likely, but maybe. Recall that the immunity decision last week was a ideologically diverse spectrum of different folks. They could still decide not to grant a stay, or they could grant one, and most importantly, they could just decide the damn issue of immunity quickly. If they do that, now it really should occasion very little delay of the trial, especially if they've let discovery proceed, and we would still be looking at an April trial. If, however, they grant a stay, take a few months to decide, and we are suddenly, it wouldn't get us to November, but it would get to the cusp of the actual general election where we have to assume Trump is a candidate. And certainly Chutkan and the whole judicial system will have a really vexing, completely issue of first impression. Do you make him, he's got to attend a trial. Do you actually make him sit in the dock and be there for the trial in the heat of an election season? So that's why he's hoping just to get a couple more months and frame that. All right, that is the DC circuit. Let me recapitulate, because this stay is now what it's all about. I think Chutkan denies the automatic stay. I think she could, but she'd make it would then go to the Court of Appeals anyway. Now the Court of Appeals, will they keep a stay on? They very well could, but the important issue will be, will they decide it quickly? And a secondary issue is, will they still let discovery proceed, just put a stay at the trial level? Now, at that point, after the Court of Appeals decides, it'll be up to the Supreme Court. And there, we can talk about that at great length if we get to it, but here's the one point I want to flag for now: the rule of five. You need for the court to take an issue, 4 votes. To stay something below, 5 votes. So at that point, let's say the Court of Appeals has made quick work of the substance. The question will be, will the Supreme Court have 5 votes to stay the case while they decide the issue? And then even if they decide there's no immunity here, they've maybe done enough of a delay to impose this very vexing question of whether you take him to trial in the middle of a campaign season. That would be the best case scenario at that point. Now, 5 members of the court, 3 of them appointed by Trump, 2 reliable conservative votes for Trump, Thomas and Alito. On the other hand, will the Supreme Court want to own, this huge intrusion on an election? Okay, see how a simple little stay motion can become so important and so complicated, but let me just summarize, and I think it's not so much. Trump says, I have an automatic stay right. It's not very persuasive. Chutkan, I think, will say, no, you don't. Trump says, grant me a stay anyway. I think Chutkan will say, no, try your luck in the Court of Appeals. Or she might even say, okay, I'll stay until you go to the Court of Appeals. Now it's in the Court of Appeals. Will they grant a stay on the immunity because there's a colorable claim? Yes, I think they will. I think there is a colorable claim, and they should hold off at least on the trial. The question will be, would they also do it on discovery? And then the important issue, will they decide it very quickly so that there's not a practical significant delay? That's what it will really come down to. And they have just decided last week a very similar case on immunity in a civil context. Okay, so that's what we're looking at. That's the stay heard round the nation. And just very quickly, the double jeopardy claim. What's the first jeopardy? The impeachment. So he says the impeachment itself was jeopardy. So now this is second. That's not going to take any court very long to say, are you kidding me? So that won't go anywhere. Immunity is different. We've known from the second it dropped. This is his serious claim to try to put the brakes on everything. We'll see if he does. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.